Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
All right, welcome back to another episode of Picking Justice. Harry, how you doing, man?
I'm good, man. I have a jury starting to deliberate this morning. Super excited. Just got my favorite alternate on there.
That's
this
always
morning.
good.
A juror who was just like total, follower called in sick. I don't mind followers, by the way, as alternates. If you have a good jury, you like your jury. I'm like, I don't mind having someone who's not going to rock the boat at all. But there was one alternate I really was hoping to get on, and she got on, so we'll see what happens.
And before we introduce our amazing guest, I do want to touch on this for a second, though, because you do have an interesting philosophy where bad jurors will excuse themselves in trial. And I've noticed you and I have talked about this. Like, if a juror really is going to fight for your client, they will move mountains to try to stay on the jury if they have a conflict.
That is true.
In your case, did the jury you lose? Were they not a good juror and then the alternate replaced a bad juror?
They weren't a bad juror. They were just a follower. It was someone who didn't speak English great. I think worked a night shift. I think she said she wasn't thrilled to be on the jury. So I have found that the ones who just really don't want to be on there tend to just not show up. They get sick or they just don't show. And yeah, I've seen ones who are great if they really like your case and they're digging your case. I've seen ones that even if they have like a vacation coming up and they'll be like, "No, Your Honor, I rescheduled it." And you're like, "Okay." I had one I remember a trial that went like 10 days longer than the judge told him, and we didn't lose a single juror. And to me, I was like, that's a great sign. Like, they want to see justice done in that case, and they did. It was a great verdict. So
usually, if they're like unless they're really pro corporation and just really want to fuck your client, then But usually, I think it's the opposite. I think they really want to.
Yeah, I wouldn't bank on that. I wouldn't be don't worry about keeping bad jurors. They'll all just sort of not show. But the ones who are like just miserable to be there and they're like, "What the heck is this case? I don't care." Like, they don't really care about sticking around. So and the ones who really do will fight to stay.
Yeah. Well, with that, I don't want to keep this amazing guest waiting when you have two different podcasters unite on here. The great Rahul Ravipudi, one of the guys I've looked up to since I started my career. Truly, now a legend in the trial lawyer game with Panesh Ravipudi. He really was. When I had my first, right when I opened my law firm, coming from the defense side, God, probably 15 years ago, we had a tragic wrongful death case. I brought it to my buddy Rob Glassman, and Rahul kind of oversaw us and really helped us get justice for our client. And he's just an amazing trial lawyer, really a good friend of mine. Rahul, how you doing? I mean, you've had multiple I could go through your verdict list, but there's so many 9-figure verdicts, 8-figure verdicts. Everyone knows who you are. So how you doing, man?
Doing good, man. Thanks, Dan. Thanks, Harry, for having me on this. I was listening to what you're dealing with, Harry, and your philosophy, both of you, on bad jurors. And it just reminded me of something, if you don't mind me sharing a story of Dave Riedorfer and I in trial out in Pasadena. We were in trial on a rear end accident case in front of Judge Plume, who passed away, but he was a very cool and decisive judge. And as we're in trial on this case, there were a lot of bad jurors, and I ran out of peremptories, and there was this one guy, Mr. Haynes, who stayed on the jury. And for whatever reason, every day, the judge would ask Mr. Haynes at the beginning of the day and at the end of the day, "Mr. Haynes, how you doing this morning?" And he'd say, "Feeling like a 9, Judge." And I'd feel good because I'm still in my case. And then at the end of the day, "How you doing?" "Feeling like a 9, Judge." And so then our plaintiff takes the stand, testifies, and then at the end of the day, the judge goes, "Mr. Haynes, how you doing?" "Feeling like a 4, Judge."
Ooh.
It's like, oh, this isn't good. And so then the jury starts deliberating, and within about an hour, there's a question. "We don't like Mr. Haynes, and we would like Mr. Haynes to leave the jury."
Wow.
And Mr. Haynes doesn't want to be here, and he would like to leave the jury. What do we do? And so the judge brought the jury in. "Mr. Haynes, how you feeling right now?" "Feeling like a 1, Judge. I sat in that room. I see what's happening, and I don't like it, and I don't want to be a part of it." And then he got removed from the jury, and then they put in an alternate, and everything turned out great for our client. But it was just talking about And listening to your comments about how outlier type jurors probably either way run the risk of, offing themselves.
So can a juror just remove themselves because they just don't want to be there? Is that a judge just can
I think it's up to every judge,
Yeah.
right? But
Yeah,
if
it is
somebody's
up to
got a
every judge.
compelling reason, I guess. But I've never seen a juror do that in the middle of
I know.
deliberations. But there've
Yeah.
been a couple times when, I mean, I don't want to act like this is something you should try. Don't try this at home. But there've been a couple times when there's been a juror. I'm like, you know what? We have more bad jurors and we have strikes. And I'm like, this one juror, I don't think this guy's going to show. And usually they don't. Like, you can tell it's not just that they're bad for your case. It's more like they're trying to get off. They have a million excuses and they're bad for your case. You're like, this guy's just going to no show. Like, he's like, I have finals next week and I have, I'm too important at work and all this stuff. And, sure enough, like, the harder they fight, the more they're just not going to show up, especially with our beautiful system here in LA where we don't really punish jurors for not showing up at all.
Do they in other jurisdictions? Have you seen?
Some jurisdictions, other states take that really seriously. They will go out, they'll send like a sheriff.
That actually happened to my wife. She,
yeah.
She's from Fresno and she still had her address there. She'd been in LA for like 5 years. The sheriff came to scared the shit out of her parents, my in-laws, came to their door with like a warrant for the not showing up for jury, and they explained it away. Thank God she's not in prison. But they do enforce it in Fresno County.
It's amazing.
Wow. So I'm super excited to talk with Rahul because, gosh, I mean, you've done picked so many great juries, and I've heard stories where you've gotten just tons of jurors off for cause, but you do it in the most polite way. I mean, I can't imagine a more likable attorney. You're not arguing, cross-examining any jurors. And so I'm super excited to talk about that. But one of the things we'd love to talk about is what is something that you do kind of uniquely, or something that you do in voir dire that you see a lot of lawyers doing the opposite way. And you're like, I wish people would learn, that's not the right way to do it, even though it's kind of conventional wisdom. What's on the top of your list?
That's a great question, Harry. I will say that there are so many different philosophies as to how to execute voir dire as a plaintiff trial lawyer, and there's a lot of great approaches. I think one of the things that people try to do, and I think is a mistake, is to try and mix approaches. If your approach is a belief that you're going to be able to build a tribe and get these jurors, no matter where they come from, their life experiences, their preconceived biases, and you're going to get them to galvanize together, then that's an approach, and you should take that approach and take it all the way to the finish line. If you're somebody with a philosophy, and one of my core beliefs is that I can't change anybody's mind on what their biases and prejudices are. They come with them. And in the 5 minutes, 20 minutes, 30 minutes that I get to talk to them, or they get to hear what I'm talking about, I'm not changing their minds. They're not changing mine. And, I just think about life in general. I've got so many close friends. We don't agree on everything. And I don't mind telling my friend, I just don't agree with you. If I don't mind telling my friend I don't agree with them, how am I going to approach a stranger who tries to ask me about a question and get me to change my mind on my belief system? It's just not going to happen. And that's part of my philosophy. And that's why identifying jurors with biases and prejudices that are relevant to the issues in our case, and then having them recognize that and then excuse themselves for cause, or at least allow me to get the cause challenge established, is my discipline.
Is that part of your intro, what you just said? I really like that a lot. But is that verbatim how you kind of do an intro?
No, sometimes what I'll do, it just depends on the venue I'm in, but sometimes just talking about different concepts and then raising that. I do bring up the friend issue, but usually it's during voir dire when I'm talking to an individual juror. It's not part of my intro discussion. But as I'm trying to explain the concept of what we're looking for here and why I'm concerned, I'll raise it.
Yeah, that makes sense, because like if they're it's basically just trying to lock them in so that the defense can't come up and try to act like they're gonna change their mind.
Yeah, exactly. And going through it in a way where they're the people talking and I'm not the one that's doing all the talking first gives the court the opportunity to say, okay, this juror means what they say. And it's not Rahul just leading them into a cause challenge. Second, it builds a lot of credibility because I've seen so many times. So I finish my voir dire, and then defense tries to do some version of a rehab attempt. And for the most part, most defense lawyers, and I'm not going to say all, but most are pretty rote in how they go about it. There's some sort of script that they've been taught, and they try to do their rehab. And so many times I've heard jurors say, no, 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 you're trying to trick me. And as I told Mr. Ravipudi, who just asked me, this is what I told him. Nothing you're saying is going to change my mind because it's my belief, right? It's part of the fabric of who I am. And then it makes it very hard for the defense to establish a cause challenge. Then if the defense really is trying hard or feeling deflated, they make the mistake of then cross-examining those jurors. And then they get disconnected from everybody on that panel. And I
That's the
think our
best, isn't
job
it?
is
Yeah.
really right. Oh, it's amazing.
When you
And
see
I've seen it where they've made
a
jurors
defense lawyer get
cry.
mad at a
It's
juror, that's the
unbelievable.
best.
Well, yeah,
Oh
when
my
you see
gosh.
like three other jurors like lean back and cross their arms, like they're not going to give him or her anything after that.
I've seen times when the defense lawyer is going, and I love when they're like, they get frustrated because they can't get cause with somebody, and they go, "How can you tell me? I've seen them get that mad. Like, how can you say that you hate corporations, but you could somehow be fair in this case?" And you're going, keep yelling at me.
Oh,
That's awesome, So
totally. There's this one time where a defense lawyer was asking a juror who was clearly, she identified herself as being biased and couldn't be fair on this particular case. And the defense lawyers asked a couple of questions, and then she gave a long answer on why. And then he said, you may have seen this on TV, but the objection, non-responsive, your answer was non-responsive. And
nice.
so here's what I'm trying to ask you. And then she just started crying. And
Shamed her.
the whole jury panel just got upset. And then the next person came up, and then he made that person cry on a different issue.
Wow.
This poor lady, her husband died from a car accident that led to a brain injury and then passed away. And she's like, I can't be a juror on a brain injury case. And then he goes, I know your husband died from a brain injury, from a car crash, but here's my question. Can you be fair in this
Oof.
case? Put that aside. Can you imagine? And this is the part about actually thinking about what you're saying and trying to build a human connection. How do you connect with anybody if you don't actually care about their feelings? So much so that you're so obtuse that you ask that question. And then she started crying. And then he said, "Hey, look, I'm not trying to hurt your feelings." And I remember it like it was yesterday. She goes, I think you like what you're doing.
Ooh.
And it just chilled the whole discussion and then he got switched out.
I know. I mean,
Another defense.
jury selection is kind of a transactional thing. Obviously, you're there for a purpose, but you can't make it seem transactional to the jurors. You have to react like a human being. And I've seen a lot of lawyers, they get a nugget for cause. Someone's like, my husband died, in a car crash, and the defense lawyer is almost like giddy about like, oh, good, so you can't be fair. React like a human being. You hear that, go, oh my gosh, I can't even. I'm so sorry that we even have to talk about this. And
Yeah.
don't just like go to cause like.
I mean, on the flip side is people who have been sued before, right? And it's been a really devastating. I mean, that would suck for any of us to get sued and then, feel terrible. I made a mistake and all that. And then I see plaintiff attorneys get giddy in the same way without being compassionate that, hey, like being a defendant or being sued is also not fun. And sure, you were negligent, but that, doesn't make you an evil person, right? So it's like the same, you got to like do the inverse too.
Yeah, and you can say, that I can't even imagine how much that would suck. I mean, if that was me, I don't know if I could be.
Yeah, exactly.
I'd be probably upset when I heard a similar accusation. I don't blame you for feeling that way. Is that kind of how you feel that way? And sort of, be a human being with them. But I wanted to ask, Rahul, like, how do you handle it when a juror who clearly has bias, but they're convinced in their mind, like, no, I could be fair. You're hearing that. I mean, obviously you're not yelling at them and cross-examining them. How do you handle somebody who seems to think that they're fair despite some belief or some attitude where you're just like, that's not fair at all?
Yeah. So just on the front end, and I really am a huge fan of Keith Mitnick's cherry pie, apple pie example, but I switch it to lemon cake and carrot cake because not a huge fan of the lemon cake. But as I do my introduction, I talk about what a bias is and how that really impacts the way you start to see, hear, and think about things. and that it's going to be in the front of your mind or the back of your mind, not just when you deliberate, but as you're hearing the evidence and seeing the evidence. And so it's the lens through which you see things. And hopefully that then gets the discussion first that you don't have to have a true visceral reaction where you're going to throw up or start screaming if you hear evidence on a particular issue. It's just that it causes you to think about it because of your life experiences in a certain way. And then hopefully that gets the discussion going. Oftentimes, and it's really not about whether you're fair. I actually truly believe everybody believes they're a fair person. And if you think they're unfair, that's just your opinion. And if you actually look at the jury instructions, this is the big struggle, but it is actually a benefit in jury selection in voir dire. When you look at the non-economic damages instruction in California, you have to provide reasonable compensation. Well, what's reasonable? Reasonable is based on your life experiences and your beliefs. And if your life experiences and your beliefs tell you that for pain and suffering, everybody has pain and everybody has suffering in their life. And I think reasonable is 0. You'd be complying with the law. So it's not about are you following the law, because a reasonable number is 0.
Right.
That's totally irrelevant. And I keep following the law out of my vernacular during my voir dire. And it's not whether you're fair, because you believe you're fair at 0. What we need to do is understand, well, what are your life experiences and what causes you to lean towards that number? And then that's really the lens through which you're going to be hearing the evidence. And that's what's going to be something when exposed that's going to get the cause challenge. Now, oftentimes what'll happen is you'll have a juror and they'll just latch into, I've said all these things and clearly cannot be entirely impartial, but I'm not going to say that and commit to that yet. Let me just say I'm going to hear the evidence and I'll let you know later, which is obviously too late. I might stop because, again, I don't want to be the person cross-examining jurors and beating up on them, but I'll stop with that person and then I'll move to somebody else. And then that person will start to explain maybe the whys behind why pain and suffering are unreasonable for, claims for which to seek compensation. And a jury trial shouldn't be a place where you do something like that. And as those things go, then I'll say, does anybody else share the beliefs of juror number 7? And then that juror may actually raise their hand and say, you know what? I just was having a hard time explaining why I don't think this is the right case for me, but juror number 7 just said it the way that I feel. And now you're ultimately, if you're patient, you're going to be able to get that cause challenge, which you deserve on that juror without actually alienating yourself from the jury.
Let me follow up on this. Reasonable could equal $0 for a jury. Is that something you're actually talking to them about, or that's something you're going to argue to the judge, I assume, right?
Yeah. A lot of judges and all the defense lawyers say, can you take the facts, apply them to the law? That's it. It's formulaic. Yes, I think I can do that. Well, that's all we want you to do here. And if you can do that, then you're an appropriate juror for this case. Plaintiff counsel or whoever else, use your peremptories. That's the wrong approach. And if I embrace that and say, look, what I need you to do, ladies and gentlemen, is you haven't heard the law yet, but can you commit to applying the law to the facts? Then I'm missing the point, because that's not the point of jury selection and voir dire. What I'm trying to do is find out what their life experiences are, their biases and prejudices, and how is that going to impact the way that they hear the evidence in the case. Then that gives me the opportunity to talk to the judge and say, Judge, please don't do this, colloquy with the juror saying, well, you haven't heard the law yet. Are you a law-abiding citizen? And if you're a law-abiding citizen, will you at least, as a juror, enforce the laws that are given to you? 99% of the jurors are going to say yes, except really the only ones who are going to say no are probably those ones who just don't want to be on the jury and think that this is my way to get out. But how is that actually the proper standard? And when the standard under the law is reasonable, then all your biases and prejudices are in fact coming into play and are highly relevant in making the cause determination.
Yeah, no, that's really good. Do you bring that up with the judge? Are you doing that like in a brief before you start? Are you doing that like at the FSC? When are you bringing up, hey, Your Honor, simply asking them or trying to rehab them on saying, if you can you follow the law? Yes, I can. Can you apply to the facts? Yes, I can. Therefore, whatever biases they've said, just get erased? Like, are you bringing that up with the judge? Like, at what point? Are you doing it when you're arguing cause later on?
I think best practices are to talk about this as early as possible with the court. And oftentimes what'll happen is you'll have that chance as Dan, where you'll go in there and go, Your Honor, so what's your format for voir dire? And then the court will start explaining, well, we'll have 12 in the box, and then I'll do a 6-pack up front. So you'll voir dire 18 jurors at any given time. And then we'll start talking about time. And I expect this whole process will take, half a day. Okay. That starts to give me a thought that, okay, well, maybe we should start talking about what a cause challenge is going to look like and how that's going to come about, and talk about what I'm going to need to accomplish that. Talk about proposed judicial voir dire. And, can I propose some voir dire for you, Your Honor, to ask that'll be helpful for, I think, both parties in identifying cause challenges. And if the court starts talking about his or her standard for cause and it doesn't align with the law, then I have a brief that I'll file as part of my motions in limine so that it can get teed up early and drive the discussion and do it in a way which is not patronizing or suggesting that I know more than the court, or, and so it gives an out for the court to then say, okay, now I've read everything, I get it. And then the process starts to go as it really should.
I think that is some of the best advice anyone listening can take, is just ask the judge, what is your standard for cause? Because, oftentimes judges have not read the cases, frankly. I mean, the case that Harry and I just tried, the judge was, he's very, very smart judge. Came from criminal, does civil, but very, very smart. And he was basically telling us you're not going to get cause, because he could see where things were going. It was a tough slip and fall. He could see where things were going. It's like, you're not going to get cause for X, Y, and Z. I forget his exact words, Harry. But then...
Yeah. He said you're not going to, if they're biased, if they're saying I'm biased based on something that they heard in the mini opening, I'm not going to grant that cause challenge, because now they're judging evidence. They have to have, if they're saying, well, I don't like that he's wearing Crocs, or I don't like that they didn't train their employees, or whatever it is, or, well, that's a fact in the case. And that's not bias, because, that's just what evidence is going to be.
But then we took it back in chambers. I had my brief ready and was reading him all the cases, like strike against, uphill battle, just all of like the verbatim. And then all of a sudden he's shook his head. He's like, okay, yeah, they did say this. They did say this. And then I'm getting the cause. But I really like the way you do it, very politely. And you're just saying, okay, so what's your standard for cause? And it's interesting because I think judges aren't often asked that question. And it's like, why aren't we asking that question with every judge before trial?
I've seen a lot of judges be asked that question and refuse to answer the question, though, because they don't want to get tied down to a particular standard. So it's great you definitely should. And you should definitely ask, I think, other lawyers who picked a jury there, what is this judge? What are their magic words or whatever? But sometimes they don't tell you. Sometimes they don't like to tell you.
And what do you do there then, Rahul? If they say, like, have you had that experience where they just say whatever the law says?
Oh, for sure. Yeah. And every judge, here you hit the nail on the head. Every judge has different magic words. Some require it to be the word bias. Some say, if you're behind, starting behind. Some say if you're at a disadvantage. And I don't know. And some jurors, interestingly enough, I'll have a panel, and in one case, am I starting behind? Just seems to be what connects with the jurors, and they all loop it and use that as their standard. And in others, it's like, I'm biased, and this, I don't even know what you mean with the starting behind. Where's the starting line? And none of that makes any sense to me. And then, a different word actually starts to lock in, and it seems to be a little bit of juror dynamics as to what words make sense. And then understanding what the judge's position on that is, and then coming back and then curing it on the next round. So the first round, I try to go belt and suspenders and get every version of the word that could be a basis for cause to establish it, and then hear from the judge on the cause challenges. And then when he or she says, yeah, well, the juror said this word, now I know that that's what I really need to hone in on the next round, and it goes faster.
I have had judges respond to the uphill battle or starting behind and say, well, you do have the burden. You do have the uphill battle. It's your job. You're the plaintiff, et cetera, et cetera.
You are starting behind.
Yeah, you are starting behind.
And now you lose.
Yeah.
Yeah, sometimes they like to say that, which is interesting. In California, luckily we have language. I think in every state there's specific language. So I think your best shot is to try to tie it as much to that language as you can. But I think you lead
But
in
who
there,
knows
right?
the
Like,
word entirely impartial? You
yeah,
know, how
yeah,
often in our everyday life do we use the words entirely impartial?
yeah.
And, and so if you're going to start to condition it to that and say that this is the process, I usually will talk to the jurors if I know that's the judge, what the judge requires, and anything else is unacceptable, then I'll use them as synonyms.
I like 100% neutral because it's the same thing, 100% neutral. And then if they say, well, no, I'm like 80%, then that wouldn't match entire impartiality. Kind of like throwing that. I mean, yeah, like you said, you throw them all out there. You pepper it with as many different phrases as you can that match the case law.
I've had a handful of judges though that, and I'm sure you guys have seen this, so frustrating, that will go, one of the things when you're putting it on the record, they're ruling on cause challenges, one of the things I take into account is their tone and their body language and other things that I'm observing. And, I've seen judges say that one guy who told you he's biased. I was observing everything and he's not, and he's fine. And that one's denied. But this other juror that, maybe the defense is, that one said that they could be totally fair, but the body language and everything, no, I'm gonna grant that cause challenge because and you're just like, what are you doing? I mean, so some judges will use their own crazy standards.
Yeah,
but
I've had that work in my favor though before. I feel like I've had some jurors have judges who say, yeah, I could tell even though he was saying this thing, like looking to the fence, like he's clearly not going to be neutral.
Yeah, I mean, I was super frustrated. I was picking a jury in Portland that has very strong rules about like once a juror expresses a bias, you really can't rehab it at all. Like nothing they say later matters. And we had one that the judge granted for the defense, and all the guy said, he never said he couldn't be fair. He never said it. The only thing he said was, he was asked, does anyone here not have a negative view of corporations? And he said, well, I'm a communist or I'm a socialist or something like that. That's all he said. And the judge granted it. I'm like, you have to tie it to, okay, you have to go a step further and say, well, so does that mean that you can't be fair to my client or whatever? It didn't do any of those things.
That juror probably wouldn't award a lot of money though. I have a feeling.
I know.
Oh, he would have. I think he would have. He was, we talked about other things. Yeah, no, he would have been a really good juror.
Couldn't imagine a communist awarding $10 million.
It's like, man, make him do the work. I understand as a judge, you're like, I've seen this a million times. This guy's always going to be unfair, but make the defense do the work. They got to do the work, right? And for us on the plaintiff side, you got to do the work. You can't just say, I think I gave that judge enough to think about. No, you got to tie it to, and therefore you could be fair or entirely impartial. So yeah, it's just funny.
Yeah. So Rahul, like you started, I really like your philosophy. It's like when you try to mix approaches into even just trying a case, if you try to emulate different people during different times, and direct, you try to be someone cross or someone else, But in voir dire specifically, we talked about, building the tribe, stick to that because you can't really do it both ways. I totally agree with you. So what's kind of your approach that you stick with? How would you categorize kind of what you do, your style?
Yeah, my whole thing is like Harry just said, I don't want to do the defendant's job for them, the defense counsel's job. My job is to identify jurors that have biases and prejudices towards the issues in my case, to get them comfortable in actually being forthcoming, honest, and transparent about what those biases and prejudices are. And if they're ones they can't set aside, lock that in. And if there's multiple reasons why they're going to be biased against my case, to identify all of those reasons, lock each of them in as a basis for a cause challenge so that they can't even get rehabbed. I hear a lot of people, anytime they see me doing it, the biggest concern they have is, well, all I've heard is negative comments for the last 2.5 hours. Your case sucks. I don't trust plaintiff lawyers. I got sued before. And I think that everybody, basically fluffs everything up and makes things up and manufactures the case. And, pain and suffering is a bunch of crap. And, whatever. The list goes on, right? There's always, it takes two to tango. So your client probably did something wrong too. And it just goes on, and everybody starts raising their hand and saying, I kind of agree on this issue and this issue and this issue. And the question comes like, can you taint the jury pool and then get it so everybody's looking at your case as if it's the worst case on the planet and you should never win? And I just got to remind myself that what I said at the beginning here, stands true. I'm not changing anybody's minds. Their beliefs are their beliefs. What I've seen is that sometimes a juror, who I'm not actually believe has any basis for a cause challenge, so I'm not asking those questions. Sometimes they'll just still raise their hand. And I'll ask, and I say, yeah, so juror number 8, what's going on? I just wanted to say I've been listening to everything that's been going on. And yesterday I was frustrated because I just heard the same questions over and over again. And then after it, I slept on it. And then today I'm listening to all of the answers. And I fully appreciate why you need to ask these questions. Because if you don't ask them, then this process will just get totally compromised.
Wow,
So
that's a
even the
great
people that are
juror right there.
yeah, yeah. And so the question then is, can you just hear the evidence and be entirely impartial in applying the evidence in this case? And they'll say, yeah, no problem. And then maybe they can, maybe they're plaintiff friendly. I don't know. Okay. That's not my job at this point. My job's just to get rid of the bad. And then if the defense lawyer is going to get up and it turns out that that person really, really wants to find in my favor, that's their job to find that out. And if they don't, that's their problem.
One thing that I always see, I'm curious to hear your take on it, is sometimes a mistake that I feel that some lawyers make is lawyers are excited to get every cause challenge that they can. And sometimes a juror will say, I don't think I can be fair because, and the reason is because they misunderstand something about the case. Someone will say, I just think your client is a faker. I mean, I saw him walk out of here and now he's saying he can't work. That seems like bullshit. We had someone kind of like that in Dan's last trial. And most lawyers will be like, great, okay, you can't be fair. So you can't, and they'll take them through the things and they'll be like, another cause challenge notch on the board. For me, I always think for those jurors, I always like to push back a little bit and say, well, that's not, actually there's a dispute about that or correct them. Well, actually, in this case, we're not saying that he can't work. How do you feel? Do you still have other issues with the case or something like that? Because, in this particular case, we probably could have tried to get him for cause.
I wanted to. Dude, I
Right.
was like, Harry, what did we do? Why are we not like, you don't want to, you want me to try to get him for cause? You're like, no. He ended up being the juror that wanted to award way more money and was the best on liability. He was like, just
it was a misconception, a
misconception, 100%.
Which a lot of times is created by the defense mini. Sometimes the defense mini, they'll say things that are total bullshit, and you're going to show them that's not true. And so, are you worried about a juror who says, "I think I'm against your client, Mr. Ravipudi, because he wasn't following his training or something"? And you're sitting there, and you're going to show these jurors he did follow his training. That's bullshit. Do you take the cause challenge, or what do you do with that juror who thinks they're against you because they're getting confused?
Of a misstatement of the fact, yeah.
If it's a legitimate confusion on the facts and it's not something that was even suggested in my mini opening or something that I was concerned about, I'd try to clarify it. But if it's, I do bring in my client for voir dire, at least so that the jury gets to see him or her. And then as I start my voir dire, I don't want my client there so that those jurors are comfortable sharing their negative opinions about that person. And I've seen, on a back injury case where a juror says, you know what, I'm actually a nurse and treat a lot of people with back injuries. And I don't think your client has one. I think he's probably overstating what's going on. There's layers of issues that I see in that circumstance where, first of all, you've got somebody who's a medical professional who's going to, in all likelihood, use their personal experiences and professionalism to trump whatever evidence is presented in the case. And second is already looking at your client with skepticism. If your client's sitting in the courtroom, they'll probably think that they shouldn't be able to sit that long or comfortably without, if they had a real back injury, if they stand, if they don't get up the way that they want, if they don't wince, if they wince, they're exaggerating. If they don't wince, they're fine. And so I think it's really case specific, but on the injury assessment, if they've already formed an opinion based on seeing my client for 30 minutes, I think normally that would be a cause challenge that I'd
Can we
want.
discuss, because this is a very important topic, and that's come up a lot recently. Recently, Gene Sullivan and one of our friends had a trial, and my trial too. It's, why are we having the client there at all? aside from direct and cross examination. And I want to preface this, I want to have this conversation because I think it's an important debate. Talked to Cale Paris about this. He says he stopped completely. He just has his client there only for when they testify, not even in for voir dire at all. I talked to Gene, and he said, based on his recent experience, he's not going to have them. He's going to do the same thing. I'm thinking of doing the same thing because I'm wondering, I know the philosophy is like, and I used to have that, and I've had this until this most recent trial. My client there, I introduce him or her, have them stand up. I have them walk out, quiet, watching them walk out. They appear normal from the outside. I want to use that as an opportunity to have people say, like your juror did, Rahul, they look fine. I can tell they don't have a back injury. And the recent one we had, Harry, one guy says he's not limping. He looks fine. And then I want to try to establish cause based on that. But now I'm starting to wonder, based on some feedback from the jurors in that case and from Gene's case, is that both times they were like, yeah, like, I don't know why you had your client there at all. It kind of like, it started in a very negative light, the way we viewed him. Same with Gene's case. They're like, yeah, we talked about it a lot in deliberation about how, why was she even there? It felt manipulative that she was even there in the beginning, that you were trying to like focus on her and all this stuff. And then they were dissecting it, the movements. And I'm starting to think like, yeah, why do we do it? Because why can't I just say, my client, he or she's not here right now because we want to get honest feedback. But if they were here, they would appear normal from the outside. They would walk in and out of here unassisted, all that stuff. I would say that. But then their imagination becomes the person looks fine and healthy, really good. By the time they would testify, it would be towards the end of my case. They've heard from all the medical doctors, all the providers. They've heard all the evidence about how this is a non-invisible injury. So that's built up. And when they walk in, they're expecting someone to look normal. If they look slightly different than their imagination was as being perfectly normal, then that can only help me. So I'm starting to wonder, like, why do we have them there at all? I'm really curious what you both think.
I mean, I'll just say real quickly, but I want to hear Rahul's thought is, I think I wrote an article years ago about kind of on the same topic of saying, having your client there is kind of like free sub rosa a little
exactly.
bit. It's true. I mean, I'm sure the reason that the court is like, well, we want them there so that the jurors can see if they recognize them, but that's no different than a witness on the witness list. But anyway, Rahul, what are your thoughts about?
That's a really great point, Dan. I do have my client there during the initial part just to introduce them. And, I have cases in all different shapes and sizes and different personalities. And so I don't know if there's a harm either way as you're talking through it. I think part of it just depends on how you're approaching even the line of questions, right? And really what I want to know is, has the prospective juror already prejudged this case? And if they're able to prejudge it, I get nervous thinking that jurors are going to go in to deliberate with skepticism on my case. I don't think that's usually plays out to be a positive thing. And hopefully the credibility, the compelling evidence, and from start to finish carries the day. So I'd have to think about that.
But let's play that out though. So just imagine the nurse person who said that. She said, I'm a nurse. I'm looking at him. He doesn't have a back injury, right? If she had not seen him and you had just said he's going to appear normal, then I guess her response would be like, it would either be,
she'd probably say, well, I have to see him. I'll judge him when I see him.
Yeah.
And she'll eventually see him.
But then you say, well, can people have, appear from the outside? And then you start that theme through her. And she, as a nurse, would probably say, they're like, what, traumatic brain injuries or whatever.
So now you're hitting the nail on the head on what's your goal?
Yeah.
Right. And so if the goal is to normalize the presentation of your client so that jurors will appreciate that you can have a back injury and still appear totally normal, great. If your goal is to identify cause challenges, then that line of questioning may actually undermine it later, as you got jurors who say, well, if they look fine, then they probably are fine. So that nurse, if we're using that person as an example, I may not find out that she's totally biased. I may not even be able to get a cause challenge on her, granted. And if she sits on the jury, first time I'm going to find out how she really feels is when my client walks in, and he walks in normally, takes the stand, sits there for 3 hours as he gets direct and cross-examined. Actually, on that particular trial, Robert Glassman did the direct exam. I told him it should be less than 45 minutes. 2.5 hours later, the day ended, and I wanted to murder
Wait,
him.
Rob,
So,
Rob,
and
wait.
then
Are we talking about Robert Glassman likes to talk?
I
Wait,
know,
what?
isn't that shocking?
Shocking. Breaking news. This is newsworthy here. I'm just kidding. Robert Glassman's one of my closest friends. He's an amazing trial lawyer.
He
Yeah.
is.
But I mean,
He
so
is.
Rahul, I mean, you could ask that nurse. I mean, I'm just talking as I'm thinking.
Oh, you
but
go
if you
for it.
didn't have your client there, you certainly could ask the nurse, hey, you've done this a long time. You've treated a lot of patients. Do you feel like your expertise, like you could sort of assess how injured someone is just sort of by just observing them a little bit, seeing them walking and things like that? And I'm guessing that nurse would say like, yeah, I could. And then, if this is one of those truly invisible injuries, she's going to be terrible. But you probably don't get her for cause.
But
on
why
that.
couldn't
Right.
I mean, like, but she's not supposed to bring in her specialized training. So couldn't you go down that path? That'd be impossible for you to set
could
aside
try,
your
yeah.
specialized training.
You could try, yeah. And she may, yeah. I think some nurses and doctors will say, no way could I set aside that training. But but a lot of them would say, well, no, I could just sort of use my common sense and judgment because they kind of blur the two.
I think it'd be tough to get her
Yeah.
for cause anyway, even if she said, yeah, he doesn't look that injured. I don't know is that a bias really, or is it like it's really, because then the judge would ask,
If she says she's already sort of decided,
yeah, but when
if
the
she's
judge
like, I
asked,
kind of decided and you'd have to overwhelm me with evidence to prove otherwise, then that's probably enough. You could get
Yeah.
her. Yeah.
I just think the judge would say, well, you're only allowed to, I think the judge would just rehab that. It'd be pretty easy rehab, I think, but look, it's a close call. I still think I'm going to try for at least my next few to see how it goes, just not having them there during voir dire and just really build up how
Yeah.
normal they look in the juror's imagination, because there's nothing more powerful than that, right? Their imagination of the client. They can only look worse than their imagination if I build it up the right way, I think. I don't know. Who knows?
That's the beauty.
Yeah.
That's the beauty of what we all do is, trying different things and seeing what works. I mean, that's, if everyone did everything the exact same way, we wouldn't have developed all these like awesome new ways of trying cases. All right. So want to thank our sponsors again. The first one is Verdict Videos. Kelly Deutsch. If you don't know Kelly Deutsch and Verdict Videos, welcome to the plaintiff bar. I know that, for Dan and myself, we work a lot of the same cases. I know for my wife and I, we have focus grouped their videos in focus groups, and jurors have loved what they've seen of these things. I've seen the increase in value and the settlement value of these cases is sometimes tens of millions of dollars more after the jurors watch their settlement doc videos or day in the life videos than before they watch the video. And day in the life videos, I don't know if you use them, Dan, but they're not just for trial. Settlement videos for mediation are an effective tool for trying to settle cases pre-lit too. I'm sure you use both of them.
Yeah, I mean, the best thing about working with someone like Kelly is that you're not handed off to some, other person, or you're just dealing with projects. Like you will get Kelly's cell phone. She knows how to talk to clients, and I think that's one of the hardest things when someone's to be invited into their home. She'll talk to the client. She'll sit down with the client. She knows how to tell a story, and she's just such a wonderful person, like truly empathetic, compassionate. She really understands what a client's going through, and that shows through in her production. And she's wonderful. We love her. She's just she contributes to the community. I know through LATLC, the charity, and all that. She's just a great person. Very easy to work with. Great pricing, and really will add a lot of value to your cases.
And I know what a lot of lawyers that I talk to love most about Kelly and Verdict Videos is they are always honest about whether they can help or not. I know there's cases where she has said, I don't think I can in this case, but I know that she's told me, our motto is video can hurt you as much as it can help you. And so I know she actually cares and is strategic about how she can help in these cases.
Which is very true. I think in general, like everyone's like, oh, I need to have the best animation. I need to have this, that, and the other thing. Sometimes less is more. And again, it's great. It's important to work with vendors who are going to be straight up with you and who are going to be honest, like Kelly, and not just want your money from the case. Like she will be straight up, and those are the best vendors to work with. Another wonderful sponsor I'd like to thank is my dear friend, Melissa Baldwin from Baldwin Settlements. She is a structured settlement broker. She's fantastic. She's one of the first people I met when I became a plaintiff's lawyer, and has just given back, just great advice. She's another one of these people you can call and just, get some advice, and she'll really go out of the way to help you out. She supports CAOC, CALA, all the, AAJ. She's a huge sponsor of all these organizations. Her and her structure team work tirelessly with the attorneys and clients, and she really makes the hard fought result easy for the client. I mean, I had a very tough case from someone who was basically homeless, and she was able to make him understand he did not have any education to speak of, barely spoke English, but get him to understand how important it was to structure the money, because a lump sum and the many millions of dollars just would not have been good for him, given, he had some issues with drugs and all that. She was able to speak to him at his level and get him a structure that really set him up for the rest of his life. And she was willing to work day and night, anytime, weekends, just to help get it done and get the best rates she can for the clients. So, and she also does not just structure. I used to think, I'd be like, look, when I was just starting out, my cases aren't big enough for you, Melissa. She's like, no. Like it's not just for the 7-8 figure settlements. It's really for all clients who just need some help to structure. And she can also structure fees, which is great if you want to put a little bit away for yourself and your family later on. So call Melissa Baldwin from Baldwin Settlements. Really great person, great friend. These two sponsors are just wonderful women that I really respect, and they run great businesses and good people. And lastly, we just again want to thank Law Pods for making this possible. These podcasts, their whole library of attorney podcasts, truly help, all of us get better. And I highly recommend you just listen to them. I put them on the car. I'm listening to all these trial lawyers throughout the country with all the experiences they have. And it's just such a great avenue, because we can't make it to courtrooms all the time, but we're hearing from the best. So thank you for Law Pods for providing that platform. I really do want to hear, Rahul, you're trying massive damages cases, but I think how you ask for money can apply to if you're asking for 500,000, a million, obviously it changes a little bit, but I want to hear, at what point in your voir dire do you start talking about money? Do you say a specific amount? Like, what's kind of the way you do it?
Usually in my mini opening, we'll talk about how much we'll be seeking in compensation, and it'll be broken down with respect to the different buckets of damages, the past medical expenses or whatever number it is. And then, my client's going to need future medical care, and there's a dispute on that, but we believe the evidence will show that it'll cost $2.5 million in the future. Then there's a whole separate category of compensation we'll be seeking for pain, suffering, emotional distress, mental anguish, disfigurement, loss of enjoyment of life, inconvenience. And there's no invoice for that. There's no medical bills. There's no chart. There's no diagrams or graphs. It's based on the experience that my client will be suffering from the date of the incident up until today, and from today for the rest of his or her life. And for that, we will be asking for, and then whatever the number is. You say the specific number in your mini opening? Yeah. Every single time? It depends. So part of it just depends on how confident that that's what I believe the evidence will bear out, and all of the work that's gone in on the front end. And sometimes I think that it shouldn't be brought up quite yet, but it's usually a judgment call. But in a lot of my recent trials, I've given the actual specific numbers. In what situations are you not going to do that? Like what kind of cases? I'll give you an example of one. I had a case maybe 10 years ago where my client was a pedestrian walking to his college. And as he was walking to his college, unbeknownst to him, a defendant leaving work and on his way home was stopping by the post office to drop off his red check, clips a car as he's making the left turn into the post office. That car then careens onto the sidewalk and hits my guy. And he ends up getting airlifted to USC, 19-year-old kid, and suffers fractures to multiple parts of his spine, has 0 surgeries, gets released from the hospital with Tylenol, in part because his dad was an addict, and so he didn't want to get addicted to any opioids or pain medication. So he just endured the pain, had no surgeries in the future, and went back to living. So it's $100,000 in past meds and, discussions about what the future care is. The defendants thought the total case should be a $100,000 or $200,000 case. I didn't do any big data 10 years ago on that case. I did a focus group, but there were so many issues in play. I didn't know. And in hindsight, I was lucky I didn't say anything, because if I did, I might have said $3 million or $4 million. And then the evidence came in, and it came in so compelling and so powerful on the harms and losses that at the end of the trial during closing argument, I recommended to the jury that they should award 20 million, and then the verdict came back at a little over 14 million. So if I don't know, and if I really don't know how the evidence is going to come in, and I don't have enough background data that gives me a comfort in saying the number that I know I'm going to ask for, I think you run the risk of losing credibility. Because if I went in and I said, I'm going to be asking for 20 million, and I didn't believe it, which I didn't on the front end, then I'm going to alienate myself from the jury. And if I didn't believe it and I was right not to believe it, and this really should have been something I would ask the jury for 4 million on the back end, they're going to look at me at closing argument and say, you don't even believe in your case. You thought it was 20 million. Now the truth came out and now it's a $4 million case. And you're just asking for that. It's probably a $150,000 case. And I'm going to get a bad verdict.
Yeah, I totally agree.
And on the backside, you're putting a ceiling. If it really was 20 million, I said 4, then I cap myself out and they're going to go, now you're overreaching. So
Yeah, I agree with that philosophy. And I think like, the cases that 85% of the people are that we have, unless it's like really like a wrongful death or really bad injuries, I think then you can kind of get away with saying, $65 million or whatever, because, jurors are going to be like, this is a catastrophic injury. You're not going to piss them off. If in the slip and fall case where my guy looked normal with a fractured ankle, if I had said, 30 million, I would have completely lost credibility. And then like the whole panel would have had to been stricken. It would have been bad. The judge would have been pissed. So I think for like most of us listening, most of the people, including myself, I just think the majority of the time you shouldn't say a specific number in that early. And Harry, what do you think?
Yeah, I mean, I know that I work with some lawyers who love to do it, and I've seen them pull it off. It's very difficult, though. I will say that, and so I think it's just much easier to. Now, I do think it's really important, and we've talked about this many times before, to at least give them a range so they don't have sticker shock. I mean, you need to say millions or many millions, or if you know for sure it's going to be like 50 million or something, you give them a general sense it's going to be a lot. But I think giving a specific number, it's a weird thing that happens. Jurors, for some reason, they hear a specific number, and some jurors just think, how the hell did you calculate that? How did you get to that? And they're like, they lose sight of the fact that like everything that they're going to hear, the lawyer knows. But somehow jurors, when they hear that, they just don't think along those lines. So I think that when you do give a specific number, you do lose a little bit of credibility that you certainly can gain back. And you can use that. I mean, a lot of good lawyers use that to get cause and say, people are mad. How could it be $50 million? Or how do you know, whatever? And then you get them off for cause. And so I just think it's safer and easier to give them a range and not promise anything and see how the trial plays out, because they'll get there. I mean, you'll get them there. And then they'll go, oh, I see why he said millions. And actually, gosh, man, this is a lot now I'm behind lots of millions, but I wouldn't have been there if you had said $82 million at the beginning. I just don't see why you need to alienate your jurors even a little bit at the beginning, when every great lawyer will tell you credibility is the number one thing. And that's the hardest thing to do and most important thing to establish early. Why would you say something that undermines it?
Well, I guess just to talk this out, if credibility is the main thing and you already know your case and you know what you're going to be asking for, then how do you lose credibility in saying what you're going to do right on the front end? And then if the
delivering
juror
on
is
it?
willing to stick with you and then, deliver on it.
It's just weird that some jurors, and it depends on the case. Yeah, if you have a case where your client, they know this person is paralyzed the rest of their life or someone has died, then I think they get it. They're like, okay, I could see how someone, but ones where it's like they don't know, they don't have a reason to know why they should be angry first. Employment case is a great example of that. You say, you tell somebody $30 million in an employment case, you piss everybody off. Even though, if it's someone like Dave Dearbertis or Bernard Alexander or something, they're going to get there. But, so I guess it does depend on the kind of case. If they can imagine it right off the bat, I think it's okay to throw out a number. But, ones like, Dan, where they see the plaintiff and the plaintiff seems to walking no limp or anything like that. And I think they just lose their mind. A lot of people just lose their minds. Even good jurors go, I don't know. What the heck are you talking about? You can win them over again, but I think you have to, why put yourself in a situation where you have to win over their trust?
But Rahul has a good point though. It's like, yeah, so if we do believe it, we obviously believe in it. We're not just asking for a ridiculous amount just to try to get it. But so the fear is that we say it and obviously the worst jurors are going to be the most vocal, right? They're going to be the most angry, viscerally. You're going to tell.
True.
So
Very true.
and then I guess is the concern if you want to do what Rahul does is like you just want to expose all the bad jurors. Is the concern, I guess, Rahul, is that the good jurors would be angry too, and then it'd be harder to find out if they're good or bad?
Is that my concern, you're saying? Or
well, yeah. Well, I guess for Harry, yeah. Is that like does it make your job as a jury consultant like figuring out, well, this juror may actually be good, but now I'm having trouble figuring out if they're good because they're angry about this dollar amount this early?
I think a little bit, yeah. I think it's more, to me, I think it's a little unnecessary. Now, I will say this though, like I said, I've seen some great lawyers totally pull it off. And if you're a great lawyer, if you're Rahul Ravipudi or Dan Kramer, I think you can pull it off because you guys are just you are so credible and you are going to win those people back. I have no doubt. I think for a lot of lawyers listening at home who haven't done it before, some lawyers, you're putting yourself in a little bit of a hole that may be a little bit of a struggle to get out of if you're not immediately establishing your credibility. But I don't think it doesn't bother me if I'm sitting there and the lawyer says a number. I'm not like, oh God, we just lost the case or anything like that. I think it's just I think it is not a huge thing. It's one that lawyers struggle with. Like, should I say a number? Should I not say a number? I don't think it's such a huge thing that you're hurting yourself either way.
Maybe we're thinking about too black and white though. Like Rahul has such a great way he present what you frame the way you're going to say it. And it is very credible the way you're framing it. So maybe it's just really how you say it, the framing you bring it up. Like, so Rahul, you were kind of starting on it. So you say, for the future medical, it's going to be 2.5 million. And then you have the whole category. And I really like how early on you're listing the different items of non-economic damages that later on, because I think that's one thing, and I'm guilty of it too, is I don't introduce early enough all of the different harms. Because in California, it's great. The instruction says you must. So the jury by law has to award for each item of harm separately. And I think it's important that you highlight that. But I think doing it as early as mini opening and every chance you get puts that in the back of their mind when they are calculating. So I really like how you do that. So let me kind of have you finish kind of how you would do that. So you say, there's a separate for, and you list the things, and then how do you frame it so it's not offensive, even if it's a big number?
So kind of just working through it, and just my thought process is I'm trying to identify, to keep it in a summary form, these tort reform jurors, right? The ones who are anti-plaintiff. And they come in different shapes and sizes, of course, right? But one of the traditional sticking points for a tort reformer is general damages. They don't like them. They think that's where runaway verdicts come from. And they've read about the McDonald's verdict or whatever else they want to talk about that has already preconditioned them to being anti-general damages, right? So then first thing we talk about is just the concept of the burden of proof and how it's much lower in a civil case like this. And then what I'll oftentimes do, if I doesn't just automatically come out with a prospective juror as I'm talking to them, say, hey, I talked about this in mini opening, but there's these different categories of damages. And I've heard a lot of people say with medical bills, hey, show me the bill. And if your client was injured and had to incur those expenses, of course, the evidence is there and I have no issue with medical bills. But then in this concept of the experience and putting a dollar value on pain, suffering, emotional distress, disfigurement, loss of enjoyment of life, inconvenience, grief, that's just too touchy-feely. And, if you're going to be asking for that much money, I'm going to hold you to a higher standard. I expect there to be a lot more. Who shares that belief? And jurors invariably will raise their hand, and I'll actually print out all of those elements of non-economic damages, put them on the screen. Say, okay, talk to me about it. And they'll say it in so many different ways. One is, you said it right, Mr. Ravipudi. Medical bills, no problem. But you got to give me more if you're going to ask for these touchy-feely damages. And then we'll walk through that. And that's just another way of them saying I'm a tort reformer. Okay, and then we'll walk them to a cause challenge. Others will say, I get disfigurement and I get loss of enjoyment of life and inconvenience. But this pain and suffering, we all have pain in our lives. And every time I have pain in my life, nobody's coming in and giving me a check. And so coming into this courtroom and saying, hey, I've got pain, and so now I should get a check, or I've got suffering, give me a check. That just doesn't sit right with me. And so you got me on 7 of the 9 or 10 elements. I'm good, but those 2, I'm not doing it. And then the whole other juror will go, yeah, it's just inconvenience. I mean, everybody's dealing with inconveniences in their lives. I can't be fair and impartial on that. Then I'll always ask, well, why? And they'll give their reason why, and then we'll lock in the cause challenge. And it'll be just one of many reasons. So oftentimes it's not just that reason, but there's other things that they talk about that certainly indicate that they were never going to be finding in favor of my client or awarding full and fair justice.
So if a juror though says, "Yeah, I'm good with 7 out of 9, but these 2," are you always going to lock that person for cause? Because to me, I mean, like that may be a really good juror for you at the end of the day. I'm just wondering, like, for you, is it like, are you kind of reading how they're saying it? Because obviously these people have never thought about this concept until 10 minutes before, maybe even 5 minutes before. Like if they say, I'm having trouble with awarding money for inconvenience, but I'm okay for, I do believe, mental anguish or mental suffering, whatever. Are you going to lock in, or are you kind of going to, it depends, like what's your...
It depends. So, just in the hierarchy of things, and I'd suggest that if you have the opportunity, use a jury questionnaire. And if you can get an agreeable one that's going to be productive, then that also gives me a lot of information on the front end. When I look at the questionnaires, I probably have already decided based on how hard they write the answers and how aggressive some of the free responses are. Okay, I think I know who my talkers are going to be and who are going to raise their hand and, aggressively say, here's the 17 reasons why I'm a bad juror for your case and you'd be screwed if you had me on your case.
I
Okay.
think one thing that you do really well, Rahul, that I've heard is that for listeners is that if a juror gives you one reason to get him for cause, you don't stop there and say, I got that guy locked in, let's move on. Like you want to go to this judge because you never know what the judge, how strict the judge is, but you want to say, there were actually 5 or 6 areas, Your Honor, that this person said they couldn't be fair on. But keep going.
Totally. And that's exactly right, Harry. And in part because I don't know how the judge is going to respond to the cause challenge. And second, I don't expect that a defense lawyer is going to be able to rehab on 7 different reasons. They may, and detached rehabilitation is inadequate under any standard anywhere. So just, hey, you identified some reasons, but will you follow the law and apply the facts to the law? I'll try to do that. Well, that's all we need. Thank you. That's detached rehabilitation. You didn't rehab on the specific aspect of the cause challenge, and you didn't do it 7 times, and that person's out. But then it also just makes the discussions easier when you have that one really anti-plaintiff juror who's vocal about it. They're going to share all the reasons, get all those out there into the open. And then how many others share any of the opinions of juror number 11 there? And someone will raise their hand and I'm in for 1, 3, and 7. Those
Yeah,
reasons,
just
I agree with them. And then you just, lock them in for cause on those 3 reasons, get the whys, and then move on to the next person.
So even though you'd be great for me on numbers 2 and 4, you're still telling us that, not
Yeah.
entirely impartial. Yeah.
Yeah.
But
1, 3, and 7 still are a defense verdict or a dollar plaintiff's verdict,
So
So
if you have a jury questionnaire or you get a little bit of a sense from the judge's questioning, do you actually intentionally go after probably the most vocal, strong person first to make it easier? Yeah. Breaking the ice is so
yeah.
huge, right?
It's so important. I mean, just imagine, and I was talking, this was one of these things, Dan Ambrose gave me this example, and I thought about it, and it's awesome because he said sometimes when he was doing his trials, if he had a jury pool that just wouldn't talk to him, he goes, have you ever gone to a party and you knew going into that party that you weren't going to know anybody, and you were just hoping somebody would reach out, shake their hand, and say, hey, I'm Tom. Nice to meet you. Tell me about yourself, and get the conversation going. Well, I kind of feel like that person right now and really trying to invite a conversation to happen. And I think it's so much easier if you are able to break that ice, not just for yourself, but for the other 59 people in that room who don't want to say a word and don't want to share their opinions. And so normalizing the negative and breaking the ice so that it's okay to say it creates such a comfortable environment. But then us as lawyers, we've got to make sure that it's appreciated that they're actually bearing their soul to you in a way that they probably wouldn't even share with their friends. They're doing it in front of a bunch of strangers. And so that's part of the discipline in being okay with hearing all the bad stuff and genuinely being okay with hearing it so that you can have a conversation with these people.
Yeah. Let me ask you, in your opening statement, then towards the end, or when you're going to talk about non-economic damages, do you put up the categories of non-economic damages in your opening? And then are you going to give a specific number always in opening? Or do you, if you're not going to do it, you said on this case, I'm not going to do a specific number in voir dire, do you still keep it vague in your opening as well?
In my opening statements, I probably will not go through each element of harm, but I will articulate each element of harm again in talking about what the evidence will be in this case and what the jurors are going to hear and who they're going to hear from. But I'm not converting it into a closing argument and saying, here's what I'm going to ask for each item of harm. Yeah.
Well, that's great.
I think that's where you run the risk of losing credibility, because at that point, I really do in my opening statement want to educate the jury on what the evidence is going to be, as opposed to truly just arguing your case. And then if I'm going to argue my case in opening and then tell them, so here's what the evidence is going to be and here's what you got to award, then what are they there for?
Yeah.
And, and if they feel like they're a useless part of this process, there's only one thing: they're either going to disengage or they're going to think that somehow I'm trying to trick them without actually gaining the credibility of putting those witnesses on the stand and proving my case.
So do you put a number on non-economic damages in opening statement?
Yeah.
You just like...
Yeah, but it'll be the same, whatever I said in the mini opening and during voir dire.
And you'll just say it without breaking it down. Yeah. No, that makes sense.
Yeah, and that'll be a short part of it. That's just kind of at the end of the opening statement. As I said in voir dire, at the end of this case, we'll be asking for. And that's it.
No, I do the same way. Well, with that, this has been great. This is one of my favorite ones. I feel like I've learned a lot. I wish I was taking notes, but I'll just have to listen to my own voice at some point when this comes out.
That's why we record these.
Yeah, I know, but I really have. Yeah.
Oh, this was so fun.
Yeah,
Thank
you. And people can subscribe to your podcast, Elevate, right, on all the platforms. I assume they can get Picking Justice. So subscribe to both and listen to both.
Yes.
Thanks a lot, man. We really appreciate it. Keep killing it. Keep educating people. Keep mentoring, because we need more trial lawyers like you out there, buddy.
No, it's my pleasure. And thank you guys for doing this podcast. I mean, I think it's one of the most overlooked things and the most important parts of practicing law is making sure you have a fair jury, and giving people the opportunity and the tools to actually allow that to happen is the only opportunity for access to justice. So well done, guys. Thank you.
Thanks.
Thank you. Yeah, it's not taught enough. And I appreciate Rahul teaches a law school class here in Los Angeles on jury selection.
Well, actually, that's Rob Glassman and I
students.
teach one just on jury selection. Rahul teaches all trial ad, right?
No, I did I know you and Rob got in the Daily Journal for doing your class. But it was long after I started my voir dire class at Loyola.
Are you surprised Rob Glassman got the media to a...
Not even a little bit. Not even a little bit. They got to get a wide angle lens for both you and Rob together on it.
Yeah, exactly. All right. Well, thanks a lot, guys. See you at the next one.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.